we have taken decisive
Under the
action
report titled
in the
Crime
interest
Rate
of all of our
Statistics
people
for 2015
to
to
disrupt
2024.
the relationship between
The authors
gang
found
leaders
that
and
the rate of
their
serious
troops.
crimes in a population of
Mr. Speaker,
100,000
that initiative has
had
borne
increased during the period from
the figures
2015 to
disclosed that.
2024.
As we are
In
all
2015,
aware,
the rate
solving the
was
problem of crime is not a quick
8.5.0
fix. There is no single
per
magic pill to
100,000
cure this
individuals.
problem. It requires a
Over the
concerted,
period, the figure
consistent,
rose
strategic
to
approach
close to
that
1,000
empowers and equips
per
the protective
100,000
services to interdict and arrest criminals.
Mr. Speaker, that is a
It requires
serious
us simultaneously
problem and a
to
serious
ensure that the justice
indictment
system
on
is
them
fully functional
all,
and brings criminals
especially
to
those
justice
of them
in the
who held
shortest
office
possible
in the
time.
Ministry of National
And
Security.
it empowers citizens to protect themselves, to feel safer in their homes. The bill
The state
which
of
we
crime
bring
and
to
criminality
this
in this
House today
country
deals with the
was
latter.
for us untenable.
The essence of the bill is to
It was
allow
left to
citizens to
fester for a
defend
decade
themselves
by
and
my
their
friends
property by
opposite.
using deadly force
This government
if
promised
necessary,
to deal head-on with crime.
when their place of abode is invaded by criminals. In so doing, we ensure
From the
that
root
we
causes
protect
to the
those
manifestations
citizens
of it,
who are faced with the kinds
and
of
we are
horrific
not
situations
afraid
that we
to
all
deal
pray as
with it.
individuals never to befall us. The government intends to protect these citizens in a number of ways. One of which is the tabling and laying and tabling of the legislation that is before us. Another of which is to ensure that those citizens who qualify are able to get licensed firearms commensurate with the threat to their persons, their families, and their friends. Practically all of the members on the front bench opposite have not one, not two, not three, sometimes 4 and 5 firearms. Yet they tell ordinary citizens, none for you, and they get to the point where they have to donate to the police. They have to donate to the police weapons which are of dubious legality. Mr. Speaker, when we speak of home invasions in narrative terms, the fact is that it is not up to now by itself a prosecutable offense in and of itself. Housebreaking is an offense, burglary is an offense, robbery is an offense, but home invasion is not. My friends opposite cared so little about the citizens that voted for them in the first place that little or nothing has been done by way of the drafting of sound legislation to add protections to our citizens from criminals for an entire decade. And that provides the context for the reform which we seek this afternoon. In the lead up to the general election, we promised that we would bring this legislation to Parliament, and today we fulfill that promise. Mr. Speaker, if you look at the bill, philosophically, it is based on a long-established maxim that a man's home is his castle. There's a rule that stems from Semain's case. It's a 17th century English decision, which establishes that there's an exception to the legal duty to retreat from an attacker. The doctrine is that a lawful occupant of a dwelling house has the right to use necessary force, including deadly force, against an invader this is what we are now doing, without retreating from that individual, if the occupier reasonably believes that the invader would commit an offense against him or others in the dwelling house. In considering this piece of legislation, questions arose as to the sufficiency of the doctrine at common law in present circumstances. For Trinidad and Tobago, the question was whether the doctrine should be reformed and how should home invasion be addressed. I referred those questions to the Law Reform Commission of Trinidad and Tobago after the Prime Minister directed me to do so, to develop a policy position for our country. And I am pleased to see that the Commission conceived of recommendations and a bill that was accepted by this government, well suited to our criminal justice system, is now before us. In its policy paper, the Law Reform Commission, the policy paper is titled Protection Against Home Invasion in Trinidad and Tobago, an examination of Stand Your Ground and other self-defense laws. The Commission found that the act of home invasion was not specifically criminalized, as I mentioned earlier, and that the Castle Doctrine, while it remains relevant, required clarity in terms of its application in our modern society. We proceeded on a series of public consultation exercises. Those were done by the Law Reform Commission and members of the government. I believe that the opposition may have done some of these consultations as well. It is my understanding that the Commission focused on the sufficiency of existing law to address home invasion. This involved determining the key elements of the activity, how they differed from acts such as trespass, forcible entry, forcible detainer, which activities are already regulated by legislation, but which does not expressly include or could be reasonably inferred to include the key elements of home invasion. The Commission drew upon the various local and international media reports, studies of incidents in Trinidad, generalized elements of home invasion. They also looked at legislative precedents throughout the Commonwealth and in certain parts of the United States. They came up with a series of proposals with respect to home invasion itself. Number one, they said a physical intrusion into a specific class of premises used primarily for domestic living, for varying individual and family arrangements, that should be the center of their attention. The intrusion, we said earlier, a physical intrusion, the intrusion into the premises should be, the focus should be, the method of entry would, in Trinidad and Tobago, often involve deceptive entry, as in the case of 6 persons who pretended to be police officers recently in November the 5th, 2025 in Siparia. And they said, alternatively, they may physically force entry, they may use surveillance to gain access, they may disable alarm systems, or use a combination of those tactics. Those who resist may or may not succeed in stopping or driving away their attackers. There may be individuals known or unknown to the invader inside the premises at the time of the intrusion. Mr. Speaker, only just last week, a senior government official was robbed at a home in Belmont in front of an elderly person and child. That experience was reported in the Trinidad Express 4 or 5 days ago, on the 21st of November 2025. The invader's approach often involves physical assaults, threats, intimidation of the occupants. The invader uses these actions to command, overpower, and diminish resistance from those individuals. The invader intends to use the opportunity of the successful intrusion to commit crime, including appropriation of property, crimes against the person, and so on. Finally, sometimes other acts, intentional or not, lead to the death of occupants. Murder or manslaughter are all too common during home invasions. The cases are numerous, the stories horrifying, and the traumas to families and communities can last a lifetime. Mr. Speaker, these features distinguish home invasion as a different type of activity from others explicitly criminalized in Trinidad and Tobago. The Commission's findings were partly guided by its study of local conditions, international scholarship, and by comparative assessments of legal developments in other common law jurisdictions. They looked at the Federated States of Australia, they looked at Canada, they looked at England, Wales, Ireland, and specific states in the United States. The stand your ground doctrine, which they came up with, is a unique and evolved legal doctrine that reflects elements of America's early jurisprudence, constitutional law, and social history. It's not the same as the English castle doctrine. That's evident by the rulings of the early American courts. English common law required a duty to retreat and gave priority to patriarchy in property rights. There was a duty to protect one's family and self-preservation. The Americans were different, and their position was also influenced by the proliferation of firearms to defend occupiers. Now I turn now to the recommendations of the Law Reform Commission. Bearing in mind the factors that I outlined earlier and the evolution of the law across the Commonwealth, the Commission recognized that reform was imperative and that the law should be modernized. They made the following recommendations. 1, codification of the Castle Doctrine to complement the current legal framework of the criminal justice system. 2, specific criminalization of the act of home invasion. 3, specific creation of 2 statutory defenses to the act of home invasion. First, relating to self-defense and defense of another against a home invader. And the second, which is slightly new, relating to the defense of property against a home invader. Now I'll turn quickly to a summary of the bill. It's only 9 clauses in length. The bill interpolates the Commission's recommendation. In crafting certain sections of the bill, the Commission drew upon the Criminal Code, RSC 1985 of Canada, the Criminal Code Compilation Act of Western Australia, Criminal Law Consolidation Act of South Australia, Criminal Act of Queensland, Australia, Criminal Law Defence and Dwelling Act 2011 of Ireland, the Criminal Justice and Immigration Act 2008 of the United Kingdom, and mutatis mutandis, they looked at the provisions in the Florida Statute, Chapter 776 of the State of Florida. The bill targets criminals by making them criminally liable for invading the homes of others by creating the offense of home invasion. At the same time, where home invasion arises, the bill provides occupiers with 2 new statutory defenses, the defense of person and the defense of property. The use of the defense is subject to safeguards to prevent misuse and to ensure protection of the law and due process. This empowers law-abiding citizens who lawfully occupy dwelling houses to stand their ground to defend themselves, others, and their property. The offense of home invasion, in brief, is the unlawful entry into, this is what is contained in the Act, the unlawful entry into a dwelling house with intent to use or threaten force. It may involve the use of weapons, firearms, or explosives. The offense will cover acts such as injury, grievous bodily harm, grievous sexual assault, rape, death, theft, or other property damage. But the offense is aggravated in the law, which I hope that you've read, by factors such as gang involvement, involvement in organized crime, invasion in the presence of children, senior citizens, persons with disabilities, or vulnerable persons. Regarding the defense of the person or self-defense, the occupier would have no obligation to retreat. He may stand his ground and use defensive force, including deadly force, if he genuinely believes it is necessary to prevent imminent death, serious bodily harm, grievous sexual assault, rape, or the commission of a serious offense. When assessing the occupier's honest belief, the court would evaluate the reasonableness of his response based on factors such as the nature of the threat, the weapons involved, the relationship history, and whether his response to the threat was proportional. In terms of the defense of property, the occupier may use force to prevent entry, remove an invader, protect their property from threat or damage, stop a criminal offense from being committed inside the dwelling house. The bill states that the use of deadly force would be justified if it is reasonably necessary to remove an intruder or to safeguard property. In relation to both defenses, the bill also provides that a person assisting an occupier in good faith, the Good Samaritan, may use the same degree of force as the occupier. To prevent abuse of the measure, the bill provides that the defense would not be valid if, one, the individual against whom the force is used has a right to be in the dwelling, the force used against the invader is grossly disproportionate, the occupier had been engaged in criminal activity, or an individual is a law enforcement officer lawfully executing duties, and the occupier knew or should have known at the time that that was so. Mr. Speaker, the bill is 9 clauses long, and I think I have given an overview of it. If I can just be permitted, Mr. Speaker, to say a few words to some of my colleagues opposite, and in particular to the member for Ruka Lopino. And in the context of self-defense, of course, I noted that the member, the good member, said publicly yesterday at a press conference that he was not afraid of the UNC. Now,
You're not afraid of him as well.
We are not afraid either.
I hear my colleagues saying the UNC is not afraid of him as well.
Absolutely.
But I want to assure him that this bill provides for self-defense, and he should not be afraid of anyone. But it reminded me, Mr. Speaker, I have a young son, and when he was 4 years old, he would tell me, think perhaps on the first occasion when I tried to turn off the light when he was about to go to sleep. He said, you know, Dad, I'm not afraid of the dark. He was terrified. But I went close to the switch and I said, you know, I need a night light for him. So I didn't turn on his, I left him with the light on that night. Of course, after that I got a night light for him. And I just wanted to tell the member that I have night lights. His face reminded me, because there was some terror in that face when he said, I'm not afraid of the UNC.
Terrified.
But I have a night light for him, and I will share it with him. I still have it. Okay? Mr. Speaker, and on a personal note, I've never been referred to the Privileges Committee. I've been here since 2003. And I welcome my visit to the Privileges Committee. If so be it, because I wish to face my accuser and explain the truth behind it. Mr. Speaker,
That should be explosive.
with those few words, Mr. Speaker, I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Establish the Offence of Home Invasion, and in that context, to provide that a person has no duty to retreat when acting in self-defence or defence of his property, to provide that a person may use defensive force, including deadly force, to protect himself, his property, or another person in his dwelling house, and to provide for related matters, be now read a second time. Member for Port of Spain South.
Mr. Speaker, in answer to the Honourable Attorney General's last segue and utterances, we say on this side, yea, though we walk through any valley, any shadow, we fear no evil, because we are comforted by the rod and the staff. That's our side. Mr. Speaker, as I enter this debate, any life lost is sad. But any innocent life taken on a mistaken belief that a person is a criminal or has criminal intent, that is a travesty of justice. In this life, it's not a dress rehearsal. This is life. And for that decease, there's no return. There's no jury. There is no opportunity to present his or her defense. And what about the person who actually does the act? What about that trauma? This is not, Mr. Speaker, a situation where a person has an opportunity to apply for bail if he falls afoul of this law, to present his defense, to say it was a mistake. This is what happened to Maria Florida Rios Perez, a mother of 4, who innocently found herself going to a wrong home to say she was about to clean it. She was killed. There is no return. She's dead. That is the mischief of this bill, Mr. Speaker. There is a problem, and we admit that there's a problem. Crime and the protection of property and persons' personal security is a problem. But this bill is not the solution. This bill is a disproportionate, lazy, populist policy from an indolent and lazy, incompetent government who does not want to do the hard work. It is the bill and it is the piece of legislation of an administration who I say is hell-bent on destroying the very fabric of this society called Trinidad and Tobago, where we say that every creed and race must find an equal place. This bill is a floating jurisprudential fig leaf, Mr. Speaker. It is vague, it is obscure, and it offends the principle of legal certainty. Before we examine this bill, and I want to take the time for the public and examine this bill clause by clause in detail to show what we say is egregious about this bill. This bill cannot be taken in isolation, Mr. Speaker. You like to say context. I would like to take this bill in the context of the actions of this government since they assumed office in April 2025. It is critical as we debate this bill that we see a government and we understand that this government simply cannot be trusted. And on this side, as the representative for Port of Spain South, who I am hearing the cries of the constituents who have elected me here every single day, we say that they are targeting certain segments of this society. Third, and the example I give to you, and I put this bill into context, Mr. Speaker, 35,000 jobs, CPEP and URP lost. That is a target of this government, of people in this society. The cancelling, Mr. Speaker, of the Independence Parade on one day, whilst they pamper, set and parade themselves.
The Speaker, please, 48-1. We are dealing with home invasion here, and he's speaking of Independence Parade.
Yes, let's skip along.
Mr. Speaker, I will slowly do what I have to do today. The cancelling of that parade one day and the pamper setting at the Tarubo Stadium the next day on the guise of
Mr.
protection.
Speaker, 48-1.
It's irrelevant. Come on. I've politely told you to skip along. What I really meant to say was, look, let's get to the relevant part of the bill.
I heard thing about night life, I heard thing about gangs, and nobody said anything. But you tell me to skip along? I'm not skipping. I'm slowly riding. Yes, that's what I said, fat boy. That's what I said, fat boy. Mr. Speaker, this bill is no different. This bill is no different from the attacks of this government on people who are expressing their views on social media when they won this election purely on social media. So, in the examination of this bill, we say it is not just about property. It is about trust. It is about justice. It is about fairness. And it is about a society at work which we say is under attack. The government seeks to pass this bill that gives citizens the right to use potentially deadly force against anyone who they perceive to be a home invader with no duty to retreat. That is the essence of the bill. It is against this backdrop that we on this side would want to examine this bill clause by clause to identify the mischief, to identify what we see is the undermining effect of our societal norms and values by this very pernicious bill. It purports to protect homeowners, but it creates far more dangers than it resolves. It undermines the Constitution, it invites vigilante justice, it threatens vulnerable persons, and it endangers all citizens of Trinidad and Tobago. The opposition supports firm action against violent criminals, and we understand what is being faced. But, Mr. Speaker, a law designed to protect citizens must never put innocent persons at risk. It must not override constitutional rights that are guaranteed unnecessarily. It must not create more opportunities for bloodshed inside the very homes it is claiming to protect. Let me now do a clause by clause, Mr. Speaker, a clause by clause on this bill to show and to support the point I am making. The Honorable Attorney General did not condescend to a clause by clause, but I will do that because I think it's necessary that the population understands what is going on. Mr. Speaker, I start with clause 3, the interpretation section of this bill. The definitions are everything in law because a definition tells you what you're working with. And clause 3 exposes the true danger of this bill. Dwelling house and curtilage. It says that the bill says that a home includes yards, garages, driveways, shared hallways, temporary structures, even boats or vehicles used as homes. If someone enters these spaces, the occupant may just legally use deadly force. Think about it, Mr. Speaker. A dispute between tenants may end up in a potentially deadly situation. Mr. Speaker, a confused elderly neighbor, as happened in Tobago.
Correct.
As happened in Tobago. All now are ripe for potentially lethal encounters. Let us go to Home Invader and see what Home Invader says. A home invader, according to the definition of this bill, means a person who knowingly enters or remains at a dwelling house in which he is not an occupant with the intention to carry out a home invasion. Mr. Speaker, when this definition is taken at its face value, it broadly describes anyone. It could be a guest who refuses to leave, a tenant in a landlord-tenant dispute, a person entering by mistake, even someone, Mr. Speaker, seeking shelter. This is the mischief of this bill. In other words, if we are correct, ordinary social life is being equated with violent crime. Someone presenting those Watchtower magazines, Mr. Speaker, what happens then? Mr. Speaker, this bill is pernicious and it has far-reaching consequences. Let us look at the definition of occupant, Mr. Speaker. May I take you respectfully for that? Occupant, everyone from owners to tenants and family members to employees, visitors and caregivers may now use deadly force. That is not the Good Samaritan principle, Mr. Speaker. That is opening up deadly force to anyone and all and sundry. And we say that's the danger of this bill. Clause 4, stand your ground. And I don't want to misquote it, Mr. Speaker. Mr. Speaker, may I allow to, thank you kindly. Stand your ground, clause 4. This clause removes the duty to retreat. Even if you can walk away safely, you are now legally allowed to escalate a confrontation. Is that the society that we wish to create in Trinidad and Tobago? International studies are clear. The Honorable Attorney General read the law reform report. What about the international studies that says that stand your ground laws increases fatal encounters? They do not prevent them. Do we want to increase fatal encounters in Trinidad and Tobago as a solution to crime? Clause 5. creates the offense of home invasion and penalties. Home invasion now includes entering unlawfully and staying after the invitation is withdrawn. If for the season we can afford alcohol, Mr. Speaker, and you parang the wrong house, you know what happens? Stand your ground. Stand your ground. Don't do it again. Using or threatening force, inflicting injury, stealing, or destroying property. Mr. Speaker, how could stealing have a consequence of death? How? In what society that respects human dignity could stealing have the consequence of death? Penalties are draconian. 20 years for a basic offense, and we understand 25 years if the offense is aggravated. But the fly in the ointment is that even if there is no intent to kill, there is still this penalty. And now I want to use my experience as a criminal attorney to give the public a warning about the perniciousness of this act. Do not trust this government and what they sell you. When you examine this bill alongside the real estate of our justice system, a chilling reality emerges because members and citizens of Trinidad and Tobago, this bill does not allow you to use it and kill someone and escape the scrutiny of the courts, you know. You still have to go through the judicial system. So let's examine that step by step. It does not take away the oversight of the court. And what it does is it widens the scope to those who can use violent force like ordinary citizens. But an ordinary citizen having the belief, so we flip the bill and we understand. So we're not talking about the invader, we are talking about the citizen in the home who has used what they consider lawful force, might end up being an accused in a courthouse for murder. What happens then? Our current judicial system, we cannot bury our heads in the sand, means that for murder, what does bail say, Mr. Speaker? Only in exceptional circumstances are you allowed to obtain bail for murder. So you say you're using stand your ground, so you're emboldened. You went, you qualified for your firearm. It's now liberal, the system is liberal. You use it, yes? You now kill someone, you say was invading your home, but you're before the courts, Mr. Speaker. The first thing, if you're charged with murder, no bail, unless it's exceptional circumstances. But let's see how long your case will take to come up. They haven't created a special court like as was done in Hinds and the Queen in Jamaica. They didn't do that. And even if a special court is created for this, that will create inequality of treatment for others who are awaiting murder trials for over 15 years. So that's not a solution. So you're before the court. And what that means in practice is that someone who may have made an honest mistake could find themselves relying on this piece of legislation, charged for murder, being denied bail, and remaining on remand in custody for over 10 to 15 years. I have not heard anyone, I've not heard the Honorable Attorney General address that issue. What about the chronic backlog in the court cases? Even with a JIPA, this cannot be cured. Under this bill, pardon? Under this bill, Mr. Speaker, even if the person is acting in self-defense, public of Trinidad and Tobago, do not be fooled by the hype of this government. They fool you all once in April. Don't be fooled in November. You end up before the courts, having to face murder charge, pay proper defense attorney to raise a defense, and you say, I was standing my ground, correct? The bill would exponentially increase the number of serious charges with no bail awaiting long periods of trial. Mr. Speaker, ordinary people could now face life or death consequences for mistake, misunderstanding in simple disputes. And that is the point I wish to make. I will no longer gild the lily. I will move on. Clause 6, home invasion. Clause 6 of this bill seeks to create a new offense called home invasion with severe penalties, culminating in the death penalty for loss of life during the offense or during the commission. On paper, it may appear to be a response to an increase in home invasions. But, Mr. Speaker, let us be clear. The problem in Trinidad and Tobago is not the absence of laws. It is the failure to enforce them properly. And that is what a PNM government did by amending the Miscellaneous Criminal Justice Act, appointing not just 3, but 13 criminal masters to speed up the process. That is what we did, because we understood that there was a need to increase the capacity in the criminal justice system. Having one courthouse, a full courthouse designated for criminal matters, including virtual hearings and VAC centers. We already have a robust criminal law under the common law. Sections of the Criminal Offences Act addresses burglary, armed robbery, trespass, grievous bodily harm. Sections of the Offences Against the Person Act criminalizes assault, sexual offences, and murder. And the firearm legislation strictly governs the possession and use of deadly weapons. These laws that exist now provide sufficient tools for law enforcement to protect citizens. This is not legislation, but this is implementation, it is policing, it is judicial follow-through, it is using a system with some vigor, what we have. Yet, Clause 6 does not address enforcement. It radically expands criminal liability, criminalizing ordinary scenarios that previously would never have been considered an offense. What about a tenant refusing to leave during a lease dispute, holding over? What happens to a tenant at will? A tenant at will now can be killed. That's what happens to a tenant at will. A confused, vulnerable guest, a family member or a child who lingers into a common space, because common spaces are now defined, Mr. Speaker. The bill conflates every domestic situation with the potential of a violent home invasion. Under Section 4, offenders can face murder charges and death penalty even where there is no intent to kill or to do grievous bodily harm. This bill must be rejected. It is to be rejected, Mr. Speaker, because it is, in our view, it is draconian, it is disproportionate, it is dangerous, and most importantly, in the delicate balance that is Trinidad and Tobago, it is socially reckless. We say it will not make homes safer. What will it do? It will encourage the use of lethal force in trivial situations. It will exacerbate domestic disputes. It will undermine the public trust in law enforcement, and it will most importantly put vulnerable members and segments of this society at risk, including the elderly, children, and most importantly, persons with mental illnesses in Trinidad and Tobago. The reality is that law-abiding citizens already are at risk, not because the laws are absent, but because enforcement is not as it should be. Yet data shows, for example, let us look at the detection rate. Let's do some science. Trinidad and Tobago Police Force data shows that detection rates for burglary stand at 15%. Introducing radically expanded definitions and extreme penalties will not solve that. It will not increase that rate. It will create more violence inside the homes. Mr. Speaker, the opposition does not oppose effective measures against violent intrusion. But Clause 6, as is drafted, is not a solution. It is a danger. A danger. And we say that it ought to be rejected. Let me go now to Clause 7. Mr. Speaker, much of what I have to say about Clause 7 applies mutatis mutandis to Clause 8, because there are different attaches, but it's the same principle that applies. So let us look at Clause 7, that of self-defense. Mr. Speaker, on its face, Clause 7 appears empowering, but upon closer examination of this clause, it raises profound questions about consistency, fairness, and practicality. Let us begin by reading into the record the government's own wording of Clause 7. Clause 7 states that an occupant has no duty to retreat and has the right to stand his ground against a home invader and use or threaten to use defensive force. That is the starting point. No duty to retreat. The occupant must stand his ground, act instinctively, act immediately, act under pressure. But then, Mr. Speaker, when we turn to Clause 7.2, this is where the contradiction emerges, because although the government said there's no duty to retreat at Clause 7.1, 7.2 subsection K requires the court to consider where there was a possibility that the occupant could have safely retreated. In other words, when the occupant in the heat of the moment says, I am relying on stand your ground because I have no duty to retreat, the court, in analyzing the situation at the end of the day as the ultimate arbiter, will consider and will have to consider under 7.2K whether there was a possibility of the occupant to retreat. So on the one hand, subsection 1 tells an occupant, you need not retreat, stand your ground. But on the other hand, subsection 2, subsection K says, after someone is injured or killed, the court is asked to evaluate whether the occupant should have retreated. Whether or not the occupant should have retreated, how does that bring back to life? How does that resuscitate the dead? Let us say that there was a ground for retreat, and the court held there's a reason. What happens to the family of that person who will now have to deal with, well, you know, the perpetrator, the homeowner, the person who is claiming under this bill could have retreated. What does that mean in a society of Trinidad and Tobago for the family? Where is their recourse in this bill? Where is their recourse? How are citizens meant to reconcile these two instructions in real time? Are you supposed to consider, well, I shall retreat, but you know if I don't retreat, the court will consider if I have to retreat? That is the real-time assessment of these two incompatible clauses, Mr. Speaker. Mr. Speaker, Clause 7.1 imagines a scenario of intense pressure. As Justice Volney used to say, in that split second, anything can happen. But juxtapose 7.1 and 7.2, when the court must examine up to 14 separate factors. Mr. Speaker, with the greatest of respect, here is what the court has to look at on the factors: the nature of the threat, the imminence of force, the availability of alternative responses, the weapons, age, gender, mental health, prior history. When a homeowner, when a person claiming self-defense is acting under the Dutch courage of stand your ground, bear in mind that a court, even if you don't consider it citizens of Trinidad and Tobago, a court will consider all these things and weigh up your actions in this context. Mr. Speaker, with the greatest of respect, how can any citizen in the dark of night, awoken from sleep, possibly contemplate all these 14 factors which the court must contemplate? Even a trained police officer, like the member for Tunapuna, honorable member, who boasted, do not process that thought process in the heat of the moment. So I concede some considerations can indeed arise naturally or instinctively, but not all, Mr. Speaker. And that is why we say that the introduction of this bill needs to be a retreat. There needs to be a retreat. And retreat doesn't mean defeat, you know. All retreat means is you're giving sober consideration, Honorable Attorney General. Therefore, the factors in 7.2g, the court also considers prior threats, past incidents, domestic violence orders. Those may be rapidly and reasonably contemplated. But are we expecting a homeowner to consider age, gender, physical capacity to assess the threat? These things, people of Trinidad and Tobago, under this legislation is going to happen in real time. And the point I am trying to make is that these clauses are not have no sibling in a real-time event. They are post-incident judicial analysis, which the occupier or the person under threat ought to consider before acting, and it's precisely my point. Clause 7.2 is not asking occupants to do these things. It is asking the court to do it after the act, Mr. Speaker. How is that reconciled? I don't know. And not just do it, but after someone is seriously injured, as a young teenager Yal was, or killed, as Flores was. Let us be honest. You are giving citizens the legal and moral permission to carry out violent action, potentially deadly action, solely based on an immediate subjective point, but you're not telling them about the dangers. Mr. Speaker, I now go to the clause. Mr. Speaker, may I ask for my additional 15 minutes, please? Mr. Speaker, clause 8. No duty to retreat as it relates to property. It gives an occupant an absolute discretion to use and threaten force. Mr. Speaker, here is my problem with this. While defending property against a criminal offense is a laudable goal, ordinary disputes for property that arises, misunderstandings or mistakes, can be interpreted as home invasion. And people can be targeted unnecessarily and unfairly. But here is my main concern about this bill. Since when in Trinidad and Tobago we have equated property with life? When did that happen? When did we descend into that abyss? That you say, well, I defended my property, I kill you. When did that happen? I understand self-protection. That's one thing. Have we descended Trinidad and Tobago to a place where you say, in defense of my property, I'm allowed to take your life? That is a mischief that cannot be cured. And it is, I say, it's unpardonable. The broader implications, Mr. Speaker, it is unprecedented in Trinidad and Tobago and our legal traditions that has always prioritized life over property. And this clause is dangerous in every aspect of its incarnation. The broader implications, Mr. Speaker. Taken together, Clause 8 expands the use of force beyond self-defense into preemptive and retaliatory strikes. It legalizes vigilantism It encourages the escalation of domestic dispute, and it places a very heavy burden on the judiciary to go back in time and interpret Section 7(2) K and G in a way that you give the homeowner the right to say, I want to stand my ground. Section 8, in removing the duty to retreat, tends to give people what I consider, Mr. Speaker, Dutch courage. 8(1) gives the occupant no duty to retreat and permits them to stand their ground and use violent force. But, Mr. Speaker, what happens now is that persons can use this section, to my mind, disproportionately. And what it does, Mr. Speaker, we say not only does it encourage vigilantism, it is not a safe piece of legislation, and it is not justified in a society that recognizes the mores and rights of our Constitution. Mr. Speaker, I go to clause 9, assisting the occupant. Mr. Speaker, I now address a troubling provision in this bill that allows any person, not just an occupant, to intervene in a so-called home invasion and use the same degree of force as the occupant. Mr. Speaker, I know you recall the case of transferred malice. What does this do? So an occupant who has a guest, the guest can extrapolate a risk and use the same force as the owner whose life is perceived to be at risk. How could this bill make any sense to right-thinking citizens of Trinidad and Tobago? This is not a minor detail, you know. It is a fundamental shift, and one that turns private citizens into armed enforcers and private homes into zones of violence. We, on this side, we oppose this in the strongest terms. It expands lethal force beyond trained occupants, opening the way for grudges to come forward, opening the way for vigilante justice, Mr. Speaker, opening the way for arbitrary actions which take people's lives. And I go back, Trinidad and Tobago. Life is not a dress rehearsal, you know. Whatever your life view is, this is life, you know. When the person dies on this field, they're dead. It drastically increases the risk of wrongful killings and tragic mistakes, and it authorizes in a way that we say that is not justifiable the use of force. What happens to a wrong address, a panic guest, mistaken identity, vulnerable people, tenants, restaurants, domestic workers, the elderly? They all become at risk because of this clause. We say that it undermines the rule of law, due process, and the constitutional protections that are enshrined in our laws. It normalizes violence by giving a legal owner and some occupant, an arbitrary occupant, a cover for armed intervention, and it promotes shoot first, ask questions later. This bill and this clause does not preserve our homes. It transforms our homes into potential crime scenes, and it labels it self-defense. If the government was truly interested in safeguarding households, then it will concentrate on law enforcement, timely justice, and beef up crime prevention instead of doing what is being done now. And I therefore urge this House to reject this clause in its entirety. Clause 10, the exception. Mr. Speaker, how much more time do I have? Just asking. Thank you, Mr. Speaker. Clause 10, the exception. I now turn to that clause, which sets out the exceptions under which self-defense and stand your ground provisions do not apply. On the face of it, clause 10 seems to offer safeguards, but Mr. Speaker, the so-called safeguards are inadequate, and we say illusory at worst. They do little to neutralize the dangers embodied throughout Section 7 and 8. The phrase grossly disproportionate force, it is too vague, and in any event, it is too late. Who will consider this grossly disproportionate force in the heat of the moment? Seriously, Mr. Speaker, are we serious? Section 10b says the defense fails where the degree of force used by the occupant is grossly disproportionate. But what constitutes grossly disproportionate? The bill does not define it. The court will have to look at all the circumstances. I suppose they will have to examine the factors under 7, 2, K, and G and say, well, they're grossly disproportionate. My point is, though, does the homeowner in real time have that latitude? And the answer is no. And similar views, that's why we said, and I said in opening, that this law offends the concept of legal certainty. In short, grossly proportionate is an after-fact filter, it is not a preventative check for the unjustifiable loss of life in this country, particularly if I link it and I juxtapose it to the concept of defending property. When did property equate itself to life, though? When did that happen? I missed something. Or is it April 28th? Subsection 10, C, D, and E disclaim protection when the occupant is engaged in criminal activity. This is standard and it's necessary. But the danger emerges from the earlier clauses. The bill defines home invader extremely broad and allows the use of force even against persons whose presence was previously lawful, Mr. Speaker. And that is the beef that we have with the broad tenets of this bill. Mr. Speaker, Section 10(3) deals with mental impairment and intoxication, limited and reactive. It's not preventative. Section 10F excludes protection of any occupant using force while substantially affected by voluntary consumption of drug or alcohol. While commendable, it only addresses one narrow risk. It ignores the widespread risk of mental illness and genuine misperception, panic, gender bias, racial bias, social bias. None of that is addressed by this piece of legislation. In a split second, all of these factors could be taken into account. That is why we say this bill ought to be rejected. Mr. Speaker, the bill expands the definition of dwelling and associated places. It allows defense of property and removes the duty to retreat. What we would want to advance here, Mr. Speaker, is that the common law seems to be very adequate as it stands now, or better equipped to deal with the situation or the dangers that the government says pose at this time. This bill fails to prevent murders based on misperception, fear, and prejudice. And prejudice is something that we must address in Trinidad and Tobago, Mr. Speaker, because we live in a land that prejudice, unlike any other country, prejudice exists. The use of deadly force to protect property, I still can't wrap my head around that. The violent escalation of domestic disputes, tenancy conflicts, mental health crises, innocent mistake, erosion of constitutional protection for life and security. If this House and if this government is serious about protecting its citizens, not to empower them to kill under suspicion, then Section 10 is not enough, and they ought to reconsider Section 7 and particularly Section 8. I went through the sections, Mr. Speaker, to show the dangers that have been created with this piece of legislation. After careful consideration of this bill, along with the definitions and powers that they create, I submit to this House that this bill is not a safeguard for citizens. It's a dangerous license for lethal force and unnecessary violence. It buys and it ties right into the psychology of violence, Mr. Speaker. The bill, by giving wide discretionary powers to individuals to use deadly force, often based on fear or suspicion or misperception, undermines the rule of law. It erodes trust in justice and runs the risk of turning our homes, neighborhoods, societies, and communities into scenes and into abysses of violence. Simple misunderstandings will now be escalated into lethal situations. For these reasons, and for these reasons, the opposition submits that this bill ought to be rejected in its current form. If this government truly wants to protect persons from violent intrusions, there's a safer, more just way to do that. We advance a solution. Preserve the existing criminal laws based burglary, assault, trespass, offenses against the Persons, Firearms Act. Strengthen law enforcement and policing. Improve prevention of crime and social investment in the society. The social investment and the erosion of, Mr. Speaker, that is why I was thunderstruck by the objection taken by the Honourable Member for Oropouche East. The erosion of people's jobs creates a society that is unjust. And they can't live it down, not even Mr. Collateral Damage. Craft legislation that is narrowly calibrated to protect life and not property. Craft legislation directed to protect life. Don't equate property with a life. And finally, Mr. Speaker, I would want to say reasonableness and proportionality is absent from this bill. Anything less than that is a surrender of public safety and a betrayal of justice. It's a danger to innocent lives, and it's a betrayal of the people of Trinidad and Tobago and our way of life as a country in Trinidad and Tobago. When one segment feels disenfranchised, the whole country suffers, Mr. Speaker, because we all have to live on this rock called Trinidad and Tobago. With these few words, I make my contribution, and we reject this bill in its current form. Thank you, Mr. Speaker.
Randy.
Mr. Speaker, let me start where my learned friend left off, where one section of the society feels disenfranchised. The whole society suffers. The whole society and a great deal of law-abiding citizens have been disenfranchised in their own homes in the last 10 years. So, who is he speaking about being disenfranchised? Because it obviously has to be the criminal class. And I realize that my learned friend left his criminal defense attorney lawyer hat. Well, he should have left it, but he walked with his criminal defense attorney lawyer hat from the court and brought it here. And what I find disturbing is when my learned friend made the reference saying that this bill targets the constituents of Port-of-Spain South. What is he saying? What is he saying? I'm on my legs.
You said it.
You said it. Yes. Yes.
Oh. Remember, he didn't actually say that. So clarify that.
Yes. How does the bill target the constituents of Port-of-Spain South? And what, hold on, and what I find...
To the Honourable Member, like he's stick breaking his ear?
For Spain South.
My apologies.
All right. Okay. Member for Toko Sagre Grande. I don't recall a member saying that. If you wrote it down, that's a matter for you.
Mr. Speaker, and what I found really disturbing is that my learned friend spent much of his contribution talking about constitutional rights. And whose constitutional rights he was referring to? I have to ask. No, I have to pause at this juncture to pay homage to the members of the Law Reform Commission for the excellent and scholastic job they've done. And this, what they have done, and much of the bill, and my learned friend ended by conceding it, that much of the bill, much of what you see here in this bill is the common law. That's what it is, the common law. So what the Law Reform Commission did is they brought the different parts of the common law that are applicable, and they've made it relevant to home invasions. That is what occurred. So I don't know what all the big song and dance is about, and that the population should be afraid of us, because what we've done is we've brought the existing common law and codified it into statute. Much of what you see here already exists. And the beauty of it, of codification, is this. As it stands now, before this bill is passed, the ordinary citizen does not know what his rights are when he's faced with a bandit at 2 o'clock in the morning in his house. The ordinary citizen does not know where to find the law on self-defense. Today I realize that even some lawyers don't. You have to go to Privy Council judgments, you have to go to judgments of the Court of Appeal, make sure that they are not conflicting with each other, and you have to basically understand what the common law is. The ordinary citizen does not have the wherewithal or the time or the expertise to do that. What this bill does is to codify much of the existing common law. And all of the complaints my friend made about much of this is after the fact. This bill, in essence, codifies and makes easy reference for members of the public, law-abiding members of the public, to know in advance, first of all, that the law of necessary self-defense as contained in this statute is there to protect the law-abiding, not as my learned friend has said. So the first thing is, my learned friend tried to attack the concept of duty to retreat. The common law says, in essence, you do not have a duty to retreat. That's the first thing the common law says. The second thing is that I don't have to wait for you to strike first. If you are in my house, and I make this point with reference to what my learned friend said about property. If you are in my house at 2 a.m. in the dark with you and your friends, should I wait to see whether you are here to steal property alone? Yeah. Or should I wait to see whether you are here to rape my daughter who you may have been looking at? Or whether you are going to kill me because I identified you? No, that is not how the law works. And all of the complaints my learned friend made, we are in essence saying there is a presumption of legality. We are saying, in essence, that if you come into my house at 2 a.m. and you are armed and I am outnumbered and I get the opportunity, and the common law says that once I have the opportunity to strike you, I don't have to wait. Unlike what some people think, your back, if the bandit's back is turned but he's still in my house at 2 a.m., what should I do? Wait for him to turn back around? Figure out if he's a Dwen? that's my opportunity, and the common law says, and this law says, that I, in the circumstances, can protect myself and my family. And remember, Mr. Speaker, as I stand up to address this House, my mind goes back to a constituent I met very early in my tenure. This lady lived in what they call unplanned communities, squatting lands, that has no electricity. And she was a victim of a home invasion. Her daughter was raped. And as a result of that, her daughter is now a shadow of herself. The daughter is now a mental patient as a result. So what is my learned friend suggesting? And he comes up with all of these, he conjectures, all of these hypotheses. What if it's a neighbor? What if it's a child? And what his whole contribution was what if. And he has no client to defend here. It's one thing, Mr. Speaker, if you have written instructions from a client who already committed an offense and is telling you, I was in this house for this reason, or that reason, or the other reason, and you are advancing his defense in court. But our clients here today are the law-abiding citizens of Trinidad and Tobago. So much of what my learned friend came here to say today was about what if and what if and what if. In essence, making up instructions in what is not a court of law. We are here to strengthen the law so that we protect the innocent who have a constitutional right to property that he doesn't seem to know or value, who has a constitutional right to security of the person so that they are not raped and robbed, who has a constitutional right to life. And we've seen home invasions in this country where persons were raped, there was robbery, they were wounded, and there were instances of death. What should we do? But he ended his contribution by saying, you know what? We in the PNM are offering solutions. Now, I want to know why he didn't offer these solutions in the last 10 years. They always have solutions after the fact. He did nothing in the last 10 years. He said it was disproportionate. He said it offends the principle of legal certainty, which it does not, because a citizen can go up online and pull this up and now have certainty as to what the true legal position is and what he's allowed to do in a home invasion, whereas he couldn't do that before. Now, I want to deal with what he called Clause 7, and he deals in essence with the law of self-defense. Now, a lot of what my learned friend from Port of Spain South said was not accurate. Well, most, or not even half of the most, as my friend would say. And he says in essence that a homeowner should be afraid because that homeowner could turn around and be charged with murder, and that the offense here, he made reference to the section, which in essence is existing felony murder. It simply codifies it. So the same scare tactics he uses to frighten the home invader and say this bill doesn't protect you, in fact it does. Because he says, what if it's a child? Or what if it's a neighbor? Or what if it's a dispute? All of these are answered in the factors listed out. What I have in here is 6.1, he said it's 7.1. It says, subject to section 9, an occupant has no duty to retreat. And the population must know that when a man is in your house, and this bill, let me make it clear, is self-defense, necessary self-defense in the context of a home invasion. It is not self-defense in the context of Juve mourning or self-defense in the context of something happening on Frederick Street and somebody snatch your purse. This is self-defense in the context of home invasion, in your castle, in your home. And I don't know what my learned friend wants when somebody is in your home. So it says, you have no duty to retreat. It says, and in determining defensive force and how you use defensive force, you have a right to stand your ground and use or threaten to use defensive force against the home invader where the occupant honestly believes that he's about to be, that imminent threat is there. Yes, he's about to be harmed, that his life or the life of another person was in immediate danger or threat of danger. What is wrong with that? And that is already the common law. So I don't know what his complaint was about. He has no duty to retreat if he believes that his actions were necessary and reasonable to defend or protect himself or another person in the course of that home invasion. He has no duty to retreat if he believes that the defensive force used was proportionate and to the threat he honestly believed to exist. But my learned friend said, in essence, it was disproportionate. And he made reference to a number of things being disproportionate, but I want to know this. How is 20 years disproportionate to a man who comes into your house looking to rape, rob, and possibly kill? How is that disproportionate? What does he want, 5 years? And to come back again and rape and rob again? It is very proportionate to the very real threat that persons continue to face. So you're on this occasion, because my little friend has said nothing, he talked a lot of nothing. On this occasion, we have to know whether they on that side are on the side of law and order and protecting citizens, or whether they are on the side of the criminal class. Let me read from the bill so that we demystify what he has said. When determining whether defensive force was reasonable, the court shall take into account the nature of the threat or force, the extent to which the force was imminent. So if they are outside running away, then the threat is not imminent. The bill pulls out all of what is contained in all of the major common law cases and spells it out here for you. Whether there were other means available to respond to the potential use of force, that is here, the role of the occupant. Let me answer him when he said, what if it's a child? Look, it's right here in the bill. The size of the home invader, the age of the home invader, the gender of the home invader, the apparent physical capabilities, and so on. So if it's a child, and you are like me, 240 pounds, and it's a, and well, San Fernando, he says 340 pounds. If it's a child, and you see that it's a child, 2 o'clock in the morning, then of course in that situation, the law does not permit you to pull out your licensed firearm and shoot the child. That's right here. So that all of these scare tactics that my friends sought to raise, all of that is answered right here in the bill, if he bothered to read it. History, whether there was a domestic violence history, the nature, duration, and history of any relationship between the parties. So if it's a landlord-tenant situation, then obviously he didn't come here to rob. He come in to say, well, listen, I'm a tenant at will, and so on. The law, this law, as my learned friend seems to suggest, does not say, well, your neighbor come, he's a tenant at will, and he come in your yard, you can pull out your gun and shoot him down. The law does not say that. The law makes it very clear that they look at the nature and history of the parties to the incident, whether there was any prior use of force, whether there were any protection orders under the Domestic Violence Act, history of interaction or communication between the parties, the proportionality of your response. So it says, in essence, that if the so-called tenant, he says, who's a tenant at will, if he's 80 years old with a walking stick and say, well, you can't throw me out on my lass, you cannot come now and take a pickaxe and start to beat the man to death and say, well, you're in my yard. No, you can't. Because this very law says you can't. So everything my learned friend has said is rebutted by simply reading the law. Is it proportional for an old man neighbor, tenant at will, shaking with his walking stick, coming in to dispute the tenancy? Is it proportionate to take a pickaxe and beat him until he leaves and next thing he's dead? That's right here in the bill, it says no. The law looks at mistaken belief. Beckford and the Queen comes to mind. Whether there was a possibility that you could safely retreat. So my friend is saying it creates a zone of violence. No, if there really is a duty to retreat, an opportunity to retreat so that you don't have to escalate it, then you can. Again, this law does not seek to create violence, it seeks to protect the law-abiding citizens in very dangerous situations. Right. Right here again, so that the public knows that my learned friend was engaging in scare tactics. That having regard, the court shall take into account, having regard to the circumstances, an occupant acting for a legitimate purpose may not be able to weigh to a precise degree, the common law says may not be able to weigh to a nicety, he may not be able to weigh to a precise degree the exact measure of any necessary action he has to take. And it says in essence whether he honestly and instinctively thought it was necessary for a legitimate purpose and any other compelling factors. So, Mr. Speaker, all of this is the common law. The common law has always said that, in essence, one, when you are under attack, and in this case, let me go again, 2 o'clock in the morning, the bandit have a gun in his hand, and he turn his back. Some people like to say, well, his back was turned, you shouldn't have shoot him. The law has always said, and thankfully it's codified here, that you don't have to wait for him to strike first. You don't have to wait. You don't have to, the court is not going to hold you to account to say in that situation, you know what you should have do? You should have wait and see what you do. That has never been the law, and it's here now. The law says when you are in that situation, you are entitled to act to repel that home invader and to repel him, if need be, if necessary, right here again in clause, if necessary, with deadly force. And once, looking back at it, it was proportionate. Once the bandit had cutlass and you pull out your licensed firearm, it's proportionate. What the law says in essence, if it's 3 little 12-year-old boys and all they have basically is metric rulers and stuff like that, you can't pull out your matic and lick them down. You cannot. So all of that is captured here. So I don't know what my learned friend was seeking to signal. Set of scare tactics. And let me go back. It makes it again clear the boundaries within which this operates. That is why the definition section makes reference to curtilage, whether it is the property you are seeking to defend is surrounded by a fence or not, or a natural boundary or not, or a combination of both, and so on. Once it's not a public place, it says in essence what deadly force is. Deadly force, according to the bill, is legitimate in keeping with the common law, and it says any force, deadly force means any use of force that is likely to cause or creates a substantial risk of causing death or grievous bodily harm. And defensive force means the justifiable and reasonable use of force by a person acting in self-defense. I have to commend this bill to you, Mr. Speaker. I have to commend it because it codifies all of the concepts of reasonableness. It codifies all of the concepts of proportionality. And these two concepts of reasonableness and proportionality are addressed squarely in the bill and with a great degree of certitude. So the public is not in any way misguided as to what their true Now, I heard, but my friend might say I misheard. And I want to answer, it does not remove the duty to retreat. I just read it here. In the whole list of factors, you have no duty to retreat. But right in the factors the court would take into account, the court would look at it and say, if in the circumstances there was an opportunity to retreat, to not escalate violence, then the court would look at that as a factor to determine whether you were honest in your statement that you were defending yourself. Because, again, by example, if the man is running away, the threat is no longer live, then why are you escalating the situation? You are no longer in harm's way. So, in essence, there's still not a duty, but the court looks, in essence, that whether there was an opportunity to retreat. And all of these factors are factors the court, not only the court looks into it, the investigators, the director of public prosecutions would have to look into it. And if looking into it, he sees that there was no need for you to use violence, then that is a safeguard, and the police and the DPP would act. Once you act unreasonably, and that has always been the law, if you act reasonably, honestly, and with proportion, with a degree of proportion, then you are always protected by the common law, and now you are certainly protected by this bill. Now, yes. Now, Mr. Speaker, I have done, like my friend, I don't think he's done much criminal cases in the last few years. He's now much of a civil lawyer. But what one must take account of, since people are saying Trinidad and the Caribbean is a zone of peace, one simply has to read the CARICOM Impacts Report. And Trinidad, which is part of CARICOM, in essence, is not a zone of peace. We have one of the highest murder rates in the world. One need only look at the statistics with respect to home invasions, which are on the rise. And this, we say, is a very good solution. Because what we are doing, we are laying the groundwork at this juncture, and very soon, as the Attorney General has said, we are going to equip the citizens with what some on the other side have 3 and 4 or 5. The citizens are going to be equipped. We in this country have to look at how other first world systems operate and how they protect. One has to look at the fact that only 15% or so of home invasions are solved. What does that say about us? On the one hand, you are complaining about how long it takes when you are inside, but on the other hand, 50 out of 100 are caught. That must be cause for concern, and it is our responsibility as a government to seek to protect all of our citizens who are subjected to these sorts of things. And it is a misconception to think that home invasions happen only in middle class and upper middle class and rich areas. Because right in places in the constituency of Toko Sandy Grande, I can make reference to places like Tattoo Trace, Brabande, and all of these places. You can make reference to these places, and there are quite a number of places in these large squatting communities where home invasions are a real thing and happen with regularity, so much so that the bulk of persons do not even bother to report it because they feel, and they might be justified in saying, so if detection rate is only 15%, then what are the chances? So a responsible government has to look at the laws and to see how the laws can protect the victim, see how the laws can protect the citizen. And this is what this bill does. This bill does not seek to protect the rights of the bandit class. This bill seeks to strike fear into the minds and hearts of the bandits. The bandits must know when they come into your house, and very soon we will give the citizens the tools. The bandits must know once they come into your house that there might be a chance, a real chance, that they might not be going out. The bandits must know it's better to, and the homeowner must know that it's better to be judged by 12 if it comes to that than be carried by 6. The bandit must know when he comes in with firepower that your firepower will be matched. The bandit must know that the citizen is protected by this law so that when he goes in, he may not come out. And that is the type of deterrent that we as a government have to provide. As my friend from Tunapuna says, they must know flowers bring in, slow singing. They must know that on the night they come into your house to rob and rape and steal, that in a few days that their parents might be singing a Jim Reeves song, a Rock of Ages. But what we cannot do, and what they are suggesting, what we cannot do is come here, sit on our hands, and do nothing. That would be irresponsible. So I don't need to go too much into what my learned friend from Port of Spain South has said, because he has said very little. I think the intention was to take up 45 minutes of saying practically nothing. When you read the bill, every single issue, without fail, every single issue is right here in the bill. All of the what if this happened and what if that happened is right here in the bill. Everything is addressed comprehensively by the work of the Law Reform Commission. So that there's nothing to be concerned about. And you have to show the public, we all have to collectively show the public that we are here about protecting the law-abiding and dealing with the criminal class. So I call on my friends on the opposite side to stand up and stop engaging in scare tactics. So I want to deal with two last bits because, as I said, there's not much more to say.
Do you wish your 15 minutes?
Not all of it, but yes, please, some of it.
Okay, go ahead.
Yes, please. My learned friend from Port of Spain South made reference to what is in essence murder felony. And this part says, where a person kills or is party to the killing of another in the course of carrying out the offense of home invasion, he and any other person engaged in the course of furtherance of the commission of that offense is liable to be convicted of murder. I have to ask, Mr. Speaker, what is wrong with that? If during the course of a home invasion you kill an occupant, should you not be liable for murder and the consequences that go with it? What is my learned friend really saying? But what my learned friend did not say, in essence, is that this really deals with what they call felony murder, which is already Section 2A of the Criminal Law Act as passed in this House in 1997. To bring back what is called felony murder, and contrary to what my learned friend is saying, the penalty here, while you are liable to be convicted for murder and with a penalty of death, there is still a discretion in the court. The death penalty here would be discretionary. We have also taken note of the fact that, like one of my constituents, who is now, as I said, a shell of herself, and a mental patient as a result of being raped in a home invasion, we have also taken account and created an aggravated form of home invasion. So that if you commit a home invasion as a gang member in organized criminal activity, or you commit it in the presence of a child who is likely to be traumatized for life, or a senior citizen, or a disabled person, or an unauthorized vulnerable person, the penalty is increased to 25 years. So we have added that extra deterrent. Now, my learned friend says, in essence, that we should not equate property with life. I don't know what the complaint is, but my learned friend needs to read the legislation. And of course, there's a dichotomy. And of course, the law says, in essence, the type of force you can use to defend someone other than yourself. And it makes a distinction. In fact, it spells it out, what are the factors that are taken into account and what you are allowed to do when it's defense of property. And a big song and dance was made about defense of another. From my recollection, I don't want to misquote the case, but Mr. Speaker, I know that you are a very seasoned, probably almost decorated appellate lawyer, but the case subject to correction is Williams and the Queen on defense of another. So my learned friend from Port of Spain South was making a big song and dance about saying that you are, why are you bringing this piece of legislation that you are not defending yourself, you might be defending someone else. What sense does it make? If someone is in your home, you invite someone in your home, and someone enters your home to kill that person or to harm that person, what is my learned friend saying? That you should just stand up and watch? And my learned friend cannot be saying that because Williams and the Queen, from my recollection, doesn't say that either. Williams and the Queen is common law and says you are entitled to act in defense of that other person, and you are entitled to use deadly force in defense of that person if it is reasonably necessary and if you honestly believe that the person may suffer death as a result of the attack. So when we included such a clause here, it was simply to be wholesome and to cover all of what the common law has already provided. So I have to close at this point, Mr. Speaker, by saying I commend this bill to all of Trinidad and Tobago. Maybe it's a little late. They had their, I don't know what they call that. I followed, I think it was probably one or two consultations. And the consultation seemed to center around, I don't know, it didn't seem to center around the victim, the law-abiding. Again, it was a series of what-ifs. So I have to hope that my friends on the other side would do as their own constituents want, because many of their constituents are victims of home invasions. So you have to do the responsible thing and put your stamp of approval to a law that gives protection to the citizen, so that when things happen in their house at 2 a.m., that they are not the ones who are being carried by six. We have to act in a manner that is responsible so that we offer protection, legal protection, being prospective, looking forward, telling citizens that these are your rights, these are your responsibilities, this is what the law allows in such situations, and this is how you are entitled to respond in such situations, rather than leaving the citizen to guess as to what their true rights and responsibilities are when they are faced in that situation. And knowing that it is now firmly embedded in statute that you have no duty to retreat, that you can stand your ground, and that the law will not expect you to weigh to a nicety the exact measure of your response, that you are entitled to respond once you honestly believe that you are under attack, and that you are entitled to use whatever force you deem necessary in that situation. Because obviously, the court is not going to hold you to their own standard because the court was not in the situation. The court was not there 2 a.m. in the morning. And would say, well, he should have done something differently. The court is going to take into your account, as this bill recommends, the court is going to take into account the level of anxiety and stress that you are under, knowing that your children could be raped, robbed, and possibly killed. And the law is going to allow you prospectively to deal with it as you see fit, once you honestly and reasonably act in a manner that is proportionate. And the law is going to protect you. Mr. Speaker, with those few words, I beg.
Member for Port of Spain South, I recognize you, but as you're aware, the tea break is 6 minutes away. I don't know whether you would prefer to start now and come back, or whether we take the tea break now and you start after the tea break.
Mr. Speaker, it may be more useful to take the break now.
Yes, very well. So we take the break and we'll come back the usual 5:15. Sitting is suspended until 5:15. Thank you very much.